Most drivers in America believe the law is simple. If you follow the rules of the road, you'll be fine. Signal your turns, keep your speed down, wear your seatbelt, don't drive drunk. Do those things, and the law will leave you alone. But after sitting through hundreds of hours of body camera footage, after reading suppression hearing transcripts where every word spoken during a traffic stop gets dissected like evidence in a homicide case, I can tell you something that most drivers never realize until it's too late. The law on the road is not just about what you do, it's about what the officer thinks you might have done. And in 2025, that gray area just got bigger. Because across the United States, new driving laws, updated enforcement strategies, and subtle legal changes have quietly expanded what police can stop you for, how they can question you, and what happens in those first few minutes when your heart starts racing and those red and blue lights appear in your rearview mirror. Most people think these laws are about safety. Sometimes they are. But the real story is how these laws operate once a stop actually begins, how they interact with human behavior, how they intersect with psychology, fear, uncertainty, and the reality that the person asking you questions already suspects something. And that brings us to a phrase I want you to remember through this entire conversation. A phrase that has stopped more criminal cases from forming than almost anything else I've seen in a courtroom. I'm not answering questions. Not aggressively, not sarcastically, not with attitude, just calmly. I'm not answering questions. You might think that sounds confrontational. You might think that sounds suspicious. But the truth is, that simple sentence sits directly on top of one of the strongest legal foundations in American law, the right to remain silent under the Fifth Amendment of the United States Constitution. But here's where this gets complicated, because the law itself isn't the only thing happening during a traffic stop. There's psychology, there's strategy, and there's a quiet dance between what the law technically allows and what human behavior tends to produce under stress. Let's start with something that surprised a lot of drivers when the new distracted driving enforcement expansions started spreading across states in 2025. You probably already know that texting while driving is illegal in most of the country. That's not new. What is new is how aggressively states have expanded the definition of distraction. In several states, simply holding your phone while driving can now justify a stop, even if the officer never actually sees you texting. The reasoning is that holding a phone suggests potential distraction, and that word, suggests, is where the law opens up. Because a suggestion becomes reasonable suspicion. Reasonable suspicion becomes a traffic stop, and a traffic stop becomes a conversation. Now picture the scenario. You're driving home from work. You pick up your phone to check the GPS. An officer sees the phone in your hand. That's enough. Lights come on. You pull over. The officer walks up and asks the question that appears in nearly every body camera video I've reviewed. Do you know why I stopped you today? Now this is the part most people misunderstand. That question isn't really about information. The officer already believes he knows why he stopped you. What he's doing is opening the door for you to confirm it. And people do it constantly. Yeah, I was probably going a little fast. Sorry, I was checking my phone. I didn't realize I rolled that stop sign. Those sentences feel polite, cooperative, harmless, but in a courtroom, those sentences become admissions. That's the moment a traffic warning quietly becomes evidence. And this is the trap, because several of the new driving laws rolling out in 2025 are built around behaviors that rely heavily on interpretation rather than clear mechanical violations. Take the new lane discipline enforcement expansions in some states. These laws target things like lingering in the passing lane, weaving slightly within a lane, or drifting over the line without fully changing lanes. From a safety perspective, the argument makes sense. From a legal perspective, it creates something prosecutors love and defense attorneys spend hours fighting: ambiguity. An officer doesn't need absolute certainty to stop a vehicle. He just needs reasonable suspicion that a violation might have occurred. A slight drift, a delayed signal, a phone in your hand, each one might seem minor, but once the stop begins, something important happens. The legal justification for the stop is already established. Now the interaction becomes about investigation. And this is where the central phrase becomes powerful. I'm not answering questions. Because the next phase of most traffic stops isn't paperwork, it's conversation. Where are you coming from tonight? Where are you headed? Have you had anything to drink? Do you mind if I take a look in the vehicle? Let me be honest with you. These questions are not random. They are designed to create openings. Police officers are trained observers of human behavior. They watch your eyes, your breathing, your hands, the tone of your voice. If you answer casually, they listen for inconsistencies. If you hesitate, they note it. If your story changes slightly 5 minutes later, that inconsistency can become the foundation for probable cause. And here's where the new DUI enforcement strategies in 2025 intersect with these laws. Several states have increased roadside impairment detection training. Officers are taught to look for subtle behavioral clues even before field sobriety tests occur. Bloodshot eyes, slow responses, overly fast talking, confusion about simple questions. But there's something most drivers don't realize. Adrenaline produces nearly all of those behaviors. Your brain doesn't process flashing lights calmly. Your body floods with cortisol and adrenaline. Your hands shake. Your voice changes. Your memory stumbles. You're not intoxicated. You're human. But in that moment, the officer doesn't know the difference yet. So the conversation continues, unless you stop the conversation. I'm not answering questions. Now let me be honest with you about something important. Asserting your rights is not always comfortable. It can feel awkward, it can feel tense, it may even make the officer slightly suspicious. This is the hard truth section most lawyers don't sugarcoat. Yes, asserting your rights can make the stop feel less friendly. Yes, it might extend the interaction slightly. Yes, the officer might look at you differently. But rights are not designed to make officers comfortable. They are designed to protect you from accidentally building a case against yourself. And that matters more than the momentary awkwardness of silence. Here's where it gets even more complicated with one of the newest enforcement areas in 2025, automated license plate scanning integration. Police vehicles across the country now use systems that automatically scan license plates and cross-reference databases in seconds. Expired registration, outstanding warrants, suspended licenses, insurance issues. All of that appears before the officer even reaches your window, which means by the time the conversation starts, the officer often already knows far more about you than you realize. That's why the conversation phase becomes so important. Because information flows both ways. Every sentence you speak adds context to what the system already displayed, and sometimes the smallest statement opens the biggest door. I once reviewed a suppression hearing involving a driver stopped for drifting within his lane. The officer approached and asked where he was coming from. The driver said he had just left a friend's house. Simple enough. Then the officer asked where the friend lived. The driver hesitated, gave a vague location, then corrected himself 30 seconds later. That minor inconsistency became the basis for extended questioning. The officer claimed the nervous behavior and inconsistent answers suggested possible impairment. The stop lasted longer. Eventually, the driver consented to a search. Drugs were found. Now here's the uncomfortable truth about that case. If the driver had simply said, calmly, "I'm not answering questions," the entire investigation would likely have ended with a warning for lane drifting. No extended questioning, no search, no felony charge. This is where the law turns. Because the Constitution does not require you to help build the case. But human nature pushes people to talk. Silence feels unnatural, especially when authority asks questions politely. Officers know this, and good officers are very good conversationalists. They keep the tone friendly, casual, sometimes even sympathetic. "I'm just trying to understand what's going on tonight. I just want to make sure everything's okay. Help me out here." But those statements are not legal obligations. They are psychological openings. And the new driving laws expanding investigative stops make those openings more frequent. For example, new move-over enforcement technologies in several states now allow officers to stop drivers for failing to shift lanes when approaching emergency vehicles. But sometimes the only evidence is the officer's observation, which means the stop begins with interpretation, and interpretation invites conversation, which brings us back to the phrase, "I'm not answering questions." Now this is the part people get wrong. Tone matters. Body language matters. You don't say it angrily. You don't argue. You don't debate law on the roadside. You keep your hands visible on the steering wheel. You move slowly if reaching for documents. You speak calmly. "I'm not answering questions." You provide your license, registration, and insurance if required by your state. But conversation stops there, because once words start flowing, control shifts, and when adrenaline is involved, words rarely flow perfectly. Your memory misfires. Your timing gets sloppy. You guess at details you don't actually remember. Later in court, those guesses become contradictions. Let me tell you something every defense attorney eventually learns. Most criminal cases do not begin with dramatic crimes. They begin with small mistakes during ordinary conversations. A nervous driver talking too much, a casual admission, a contradictory timeline, and one more thing you need to understand. Sometimes officers will continue asking questions even after you assert your right not to answer. This doesn't mean your rights disappeared. It means they're testing consistency. Because another legal principle exists. If you voluntarily start talking again after invoking your rights, those statements may still be admissible. So if you say the phrase, you stick to it. I'm not answering questions. No elaboration, no explanations, just calm repetition if necessary. This isn't about being difficult. It's about being disciplined, because discipline protects you when adrenaline is trying to sabotage you. And remember something important. Police officers themselves operate under intense pressure too. Their job involves constant uncertainty, potential danger, and rapid decision-making. That pressure makes them attentive to anomalies, drivers who ramble, drivers who contradict themselves, drivers who appear overly eager to explain. Those behaviors trigger curiosity. Curiosity leads to investigation. Investigation leads to evidence. And evidence leads to courtrooms where every word gets replayed in slow motion. Now let me circle back to something that's quietly becoming one of the most significant changes in modern traffic enforcement. Data. Modern patrol vehicles record nearly everything. Body cameras, dash cameras, audio recordings, plate scanners, GPS timestamps. Your words during a stop are not just heard, they're archived. Weeks later, a prosecutor can replay your conversation frame by frame. Why did you say you left the restaurant at 9 wows when the receipt shows 9:18? Why did you say you weren't using your phone when the officer observed it in your hand? Small inconsistencies suddenly carry weight, and those inconsistencies often exist because people were simply nervous, which brings us back to the central idea. I'm not answering questions. This phrase doesn't accuse the officer of wrongdoing. It doesn't escalate the encounter. It simply removes the one factor you fully control, your own statements. And here's something most drivers don't realize. Silence cannot contradict itself. Statements can. Now you might be wondering about exceptions. Yes, there are a few. Certain states require drivers to identify themselves during a lawful stop. Refusing to provide identification when legally required can create additional issues. But identification is not the same as interrogation. You provide the legally required documents, and the rest remains silent. Now this is where many people start worrying. What if the officer gets angry? In my experience reviewing body camera footage, anger is actually rare when drivers remain calm and respectful. Officers deal with hostile behavior constantly. Calm silence is far less confrontational than people imagine, and more importantly, silence prevents the interaction from drifting into investigative territory. Because once the routine citation or warning is issued, the legal justification for the stop begins to expire. The officer cannot prolong the stop indefinitely without new reasonable suspicion. Conversation often provides that suspicion. Silence rarely does. So here's what I tell people who want to protect themselves without turning a traffic stop into a confrontation. Practice the phrase before you ever need it. I'm not answering questions. Say it calmly. Say it naturally. Because when those lights appear in your mirror and adrenaline spikes through your bloodstream, you will not rise to the level of your intentions. You will fall to the level of your preparation. If you've never said the phrase out loud before, your brain will hesitate. You'll start explaining. You'll start filling silence. You'll start talking. And that's how most roadside investigations actually begin. Not with guilt, but with words. So rehearse it, in the car, out loud, until it feels normal, until it feels automatic, until that moment when a uniformed officer leans toward your window and asks the question that has started thousands of criminal cases across this country. Where are you coming from tonight? And without anger, without fear, without drama, the words simply come out the way you practiced them. I'm not answering questions.